Welcome to the Ottawa Business Journal's live broadcast of Your Contractor Might Be an Employee. Here's why that matters. I'm Michael Kern from the Ottawa Business Journal. Thanks so much for joining us for one of these live broadcasts. Today, I think we're really touching on one of those fundamental employment law issues. This is something that every business owner, entrepreneur, manager, and HR professional must. I repeat, they must understand. If not, there's going to be big ramifications. And here's the issue at hand. Before engaging someone as an independent contractor, it's important for employers to consider whether the role truly fits that classification. Misclassifying a worker as a contractor when they're actually an employee can expose a business to significant legal and financial liabilities. And that's why it's crucial to understand the differences between, note these terms, employees, dependent contractors. That one's a little bit new to me, to be honest. Dependent contractors and independent contractors. Here's what you will learn today. The legal test for distinguishing employees, dependent contractors, independent contractors, how legal entitlements differ for each category of worker, and what can go wrong when a contractor turns out to be an employee, and how to avoid that costly mistake. As usual, when we're discussing these employment law matters, we turn to our friends at Eamon Harnden LLP. Founded in 1987, Eamon Harnden is home to the largest group of lawyers specializing in labor and employment law in the National Capital Region and elsewhere, by the way. They're what you call a boutique law firm. And if you're not familiar with that term, what it means is they're specialists in this. This is all they do. Our guest today provides practical guidance to employers, enabling them to efficiently manage their workplace matters at every stage of the employment relationship in a proactive and practical manner. That's what I really like about our friends at Eamon Harnden. It's always like real world advice, which is what the entrepreneurs, business owners want. She draws on her background in civil litigation, excels at delivering cost-effective and strategic solutions, equipping clients to address potential legal disputes. Please welcome Zoriana Priadka. Hey, Zoriana.
Hi, thanks for having me.
You are back for your third time.
That's right.
You're like the designated spokesperson for Eamon Harnden now, which we really appreciate. It means that we can have a little bit of fun. We're gonna accomplish lots of business things here, but we can have a really good discussion. And as I said in the lead up, Zoriana, this is one of those issues that I have noticed throughout my career. I've owned a few businesses, so to be transparent, I've had to ask the questions. You're going to help educate me here today. But I think these issues often pop up when a business or organization is looking to scale up. So the scenario is, oh my goodness, we need someone to do this. And then, you rush into agreements with people. And sometimes you might think, hey, we're hiring a contractor for just this specific purpose. But as it turns out, they're an employee. Is this something that you see and your colleagues at Eamon Harnden see frequently, Zoriana?
That's exactly right. I would say we generally see clients coming to us at either the beginning of the relationship when they have someone in mind. They think, okay, we want to hire this worker, but we're not sure how to structure the relationship if they're going to be an employee or an independent contractor. So they come to us, or like you're saying, if they're trying to scale up, they're adding on new workers. And again, same sort of discussion about, well, how are we going to arrange the relationship? Or on the other hand, we see them at the end of the relationship when the client comes to us and says, oh my goodness, I've had this contractor for 20 years and now they sent us a demand letter claiming to be an employee. What do we do? So
Yeah, exactly. And maybe we'll get into this in the Q&A later. When I think of this issue, I also think to one of the big trends in HR, which is remote work. And I think sometimes, we might trick ourselves as business owners or entrepreneurs that, well, they're working at home. They must be a contractor. And anyway, we'll get into that a little bit. We're going to give everybody a quick overview of what we're doing. We always, in these live broadcasts, try to break things down into three, so very digestible components. Topic number one will be the big one, distinguishing employees, dependent contractors, independent contractors. Topic number 2 will be different legal entitlements for each category of worker. And topic number 3, what can go wrong when a contractor turns out to be an employee. If you're a business owner or entrepreneur, you better pay attention to that one, because you're going to find out it can cost you a lot of money. Sometime, if you're watching this live around 12:25, we're going to go to our live audience. If you're watching live, you can ask either on YouTube or LinkedIn questions of us. We really, really want this to be interactive. So we're going to be looking for your questions. And one of my colleagues, Susan, is going to be running a live poll on the YouTube platform, I think. All right, Zoriana, we're going to hand things off to you for topic number 1, which is, again, distinguishing employees, dependent contractors, and independent contractors. Tell us more.
So we'll start off with just classifying the 3 different types of workplace relationships in Ontario, and that is the employee, the dependent contractor, and the independent contractor. And I like to think of it as being almost on a spectrum, where you have employees on one side, independent contractors on the other, and this sort of gray area in between of a dependent contractor, which is sort of a bit of a beast of a different nature. But we'll get into sort of what those different areas are, what they mean, and of course, what kind of factors determine that classification. So it's not sufficient to just agree with the worker that we are classifying you as an independent contractor. Here's your independent contractor agreement, sign here. The courts are really going to be looking at, well, what's the day-to-day look like? Is this worker truly a contractor? Do they meet the test for it? Or are they an employee or a dependent contractor? So to start off, there are many cases, but the Supreme Court of Canada, Ontario courts, they've all decided that, or they have emphasized that the test is a very contextual and fact-specific analysis. We're looking at the day-to-day to determine the actual relationship and the actual status of the worker. So they look at certain key factors. We'll go through those now, but essentially we're looking at things like level of control that the company has over this worker, the exclusivity of the relationship, also who owns the tools to do the job, what sort of financial risk or opportunity for profit does the worker have in the relationship, and is the worker integrated into the company's business? So to break that down, starting with level of control, the more control that a company has over a worker, the greater chance that a court or decision maker is going to find that this is actually an employee. So we're looking at things like truly the day-to-day. So who has control over when they start work, how long they're working, what they're doing during the actual day. Are they reporting to someone from the company? Is the company directing their work? Is there a potential to discipline, or is there a performance review of this worker's work? Is there, are they solely provided a product and said, and told, you're selling this product and here's how, here's when, here's to whom? Are they allowed to hire their own workers, to delegate work? Are they allowed to refuse work? Are they allowed to choose what kind of work that they're doing for this company? All of those questions go to the overarching level of control that a company has over the worker. And the greater the level of control, the more likely this worker is an employee. Exclusivity of the relationship is also a very key factor. And in that front, the courts will look at, is this worker working full-time exclusively for one company, or is this worker allowed to have other clients? Are they working for 3 or 4 different companies providing these services, or are they solely exclusive to your company? And if they are exclusive, that's a pretty big argument to say that they're actually an employee, that they don't really have the ability to control their ability to take on other work. They're exclusive. They're not able to expand their sources of income, so to speak. There's also the question of ownership of tools. So are you telling this worker, here's your laptop, here's your equipment, here are your tools, do the job, and then return the equipment back to us? If so, they might be an employee. If they are, for example, in the construction context, are they somebody who has their own tools, is contracted to, let's say, tile a certain area of a home, attends at that home, tiles and leaves, and they have their ownership of the tools from start to finish of the job, then they might be more of a contractor. We're also looking at questions such as financial risk and opportunity for profit. Can this worker take on more work? Can they expand their business and hire helpers and take on more work from the business and expand their ability to profit? Is there risk in that sense? Are they able to be in business for themselves? Are they able to control how they work, how much they work, and their profit margins? And that also goes to if they are selling a product, are they in charge of the price of that product? Can they profit off of that? Or are they just being dictated by the company that this is the product that you're selling and this is the price? And lastly, we're looking at also the integration of the worker into the workplace. We're looking at things like, are they attending at the company's barbecues? Do they have a business card? Do they have an email signature that implies that they are more of an employee, part of the team, et cetera, as opposed to sort of an arm's length commercial relationship as a contractor? So the courts are looking at all of these factors holistically. There's no one factor that will tip the scale. We're looking at a balance. We're looking at overall day to day, is this employee tipping the scale towards an employee, or sorry, is this worker tipping the scales towards being an employee or tipping the scales towards being a contractor? And the test doesn't end there. We then look at if this worker is likely a contractor based on these factors, based on the holistic overview and the analysis. Is this contractor exclusive or so dependent on this company that they would be deemed a dependent contractor? And that's the sort of gray in between area we're looking at when we're talking about that in between worker. A dependent contractor is neither an employee nor a contract nor an independent contractor. They're sort of in between. They do have certain entitlements, certain rights that an employee would have, not all, but they are less independent than an independent contractor. So when we're looking at dependent contractors, we're looking very much at if they're solely or mostly working for your company, they are dependent on you for their income, then they might be a dependent contractor and they might have certain entitlements like to reasonable notice of termination, like an employee would, and they might have the right to unionize as well, like an employee would. So those are the three kind of categories. And within that, um, again, very holistic, very broad kind of analysis that the courts are looking at and extremely fact specific.
Yeah, the dependent contractor is completely new to me, so thank you. Thank you for enlightening me on this. Um, uh, you said many things there. One that maybe we should underline is that it's not one factor that determines this. So I think if you're taking, I hate to say this, an unsophisticated view, you could say, well, they brought their own laptop to work, they must be a contractor. Or I didn't tell them what days and hours of the work, days and hours to work, so they must be. So I get that. I like what you said. It's a scale, and it's a number of factors. So probably on the simple side, Zoriana, we could say, um, I'll just check this with you. If I tell you, and I get the factors thing, if I tell you you're working Monday to Friday, 9 to 5 at my location, you're probably really tipping the scale to an employee.
You could be. You definitely could be. And the courts are going to look at all those factors, but that might be the one factor that they say, look, we can't see past that. They're an employee.
Yeah. And understanding this complexity to this, but I'll go to the very other side in my head, at least, of the spectrum, which is, you know, I bump into someone at a networking event. They tell me they do social media marketing, and I say, "Hey, I want you to help me with that." And we come to a agreement for them to provide work every week for a fixed period of time. I'm not providing my place of work. They're billing me based on, whatever their rate is. Potentially, they get a commission. Like that factor, I guess, is what I'm saying. That's kind of the other end of the spectrum, right? Like someone
Exactly.
is a service provider. They're clearly not an employee.
Exactly. And the issue with dependent contractors is that nobody sets out the relationship to say, here's your dependent contractor agreement.
Yeah,
Really, we start off by saying you're either an employee or
yeah,
you're an independent contractor. And then the surprises come at the end when we realize, look, this person, yes, maybe they're a contractor, but they're getting 100% of their income from you.
yeah.
Maybe you've allowed them to have other clients, but they've chosen not to. Then we're getting in that kind of gray area of, well, are they dependent on you to the point where they're a dependent contractor?
That's
So
what I've heard over the years, that, even if you've set up an independent contractor, but you affect, and they, as you just said, they're able to get other clients, but they haven't, and you're like 100% or close to 100% of all their the remuneration, their revenue, then guess what? You might have thought you had a
Mhm.
contractor, but you don't. Anyway, this is great. This is what we're going to continue to dig in, and a reminder that Zoriana is going to be available for all of you sometime around 12:25 for our live audience. Let's go to topic number 2, Zoriana, which is different legal entitlements for each category of worker. Let's dig into that.
Yeah, and so what does this all mean? What does it matter? What are the differences between them? It's not so much just the name and the classification, it's what are the ramifications of that. And just as a final note on our discussion, it's disappointing, but sometimes within the workplace, when we have this kind of setup, let's say a client has independent contractors that they've had since day one of the organization, and they just have this whole group of people that they've deemed to be independent contractors. Because the factor analysis is so fact specific, they could be on the hook for one worker to be deemed a dependent contractor or an employee, whereas the rest of their colleagues are truly independent contractors because it's so fact specific. It's so dependent on this person's day to day, which might be different from another contractor's day to day. But anyhow, in terms of why it matters, there's, taking a step back, when we're looking at an employment relationship, there is a power imbalance between a company and an employee. The company is, sophisticated. They have the ability to deem the or to dictate the terms of employment. They provide the contracts. It's sort of sign it or don't. There's usually very little negotiation, and the courts are very cognizant of this. They're very employee friendly because they understand that there's a power imbalance here. And so those employees have entitlements under legislation to minimum employment standards. And, when we're looking at that, those standards will be limits on hours of work. There will be vacation pay entitlements, statutory public holiday pay entitlements. There'll be things like overtime entitlements, potentially, protected leaves. All of these protections under legislation, it's meant to be there to protect as many workers as possible that would fit that definition of employee. And what's important to remember is that you can't contract out of legislation. So it's not enough just to have an independent contractor agreement and to have the other side's agreement. The CRA can still audit, Ministry of Labor can still audit. Your employee can change their mind and decide that they're an employee after the fact, even though they've signed an independent contractor agreement. So it's not enough just to have the contract. We really do need to look at the day-to-day relationship to see whether that employee is entitled to those protections under legislation. And those employees, when they're provided with their paycheck, there are deductions statutorily that are required. There's income tax deductions, there's CPP, EI deductions. Whereas with a true independent contractor relationship, you have very much a commercial agreement. It's a relationship where it's one company with another company. Usually the independent contractor is incorporated, sometimes they're not. But the idea is very much that it's an even playing ground, and they're entitled to whatever notice you set out in the contract. They're not entitled to reasonable notice of termination at common law. The idea is that they're contracting whatever's in the contract, whatever they agree to, it's like a commercial agreement. Employees, there's a lot more leeway with the courts in terms of protecting them, making sure that they have certain minimum entitlements. And of course, dependent contractors are sort of that in between.
Okay. One thing that I liked about what you said is you reminded us why all of this matters, and it is that power imbalance, right? So I guess, as you said, the courts are looking to make sure that employees are protected and not being taken advantage of. Otherwise, we would call everyone a contractor, right, Soriana, and say, I have no requirements or
Yep.
requirements to this group of people that works for me. I don't have to pay EI, or I don't have to pay provide reasonable notice or that. So really, that's a foundational concept here, right? So the
Mhm.
courts are looking to protect employees, and that's one of the reasons why we really need to take this seriously. Both in topic 3, I think we're going to talk about some of the consequences of not getting this right, but it's good just to remember the why. Topic number 2 to me really speaks to that. Listen, we're going to go to topic number 3. We're making good time, and I'm noticing, by the way, the questions are piling up. Yeah, people are eager to ask you all sorts of questions.
Great.
We'll put you on the hot seat here just a few minutes. Before we do that, let's conclude with our third and final topic. Then we'll go to those questions, and it's about the consequences, right, Zoriana? It's what can go wrong when a contractor turns out to be employee. This one
Yep.
sends shivers down my spine.
Well, and it's important to remember, why does this matter? Who cares? What's the classification really do? There are implications of it. There are real world examples of this happening to companies where suddenly they're served with a demand letter and the employee says, or the worker says, I know I've been working for you for 20 years as a contractor, but actually I changed my mind. I'm now an employee. I got legal advice and I'm looking at, these factors and I think that this is an employee relationship, and they will seek things like a termination package or a severance package and vacation and public holiday pay, et cetera. And suddenly a company is faced with this sort of shock of, well, I thought we were all in agreement, but really the courts are going to look at the factors, right? It doesn't matter what you call them. It doesn't matter if you have an agreement in place that says they're a contractor. Essentially, we're applying the if it quacks like a duck and if it walks like a duck, you can call it a giraffe all you want, but it doesn't even matter that you have them sign a contract saying they're a giraffe. The courts are still going through this analysis to see, based on the factors, are they truly an independent contractor or are they an employee? And so penalties that could arise if you misclassify someone is, the CRA may not like that you're cutting out the middleman and you're not, taking deductions for income tax and CPP and EI and all those things. The employees might commence legal proceedings. There might be a Ministry of Labor investigation where they are looking at the same test to see, is this employee or is this worker entitled to minimum standards protections? Are they not? So there's financial consequences potentially to misclassifying, and that's important because if you have a company where you have multiple independent contractors over a long period of time, the liability could be significant. So how do we minimize the risk? One, of course, is having an independent contractor agreement in place that has those provisions that you want to see, like, confirming their status as an independent contractor, confirming they're responsible for their own taxes, they're responsible for their own insurance, they're responsible for indemnifying if there's ever a dispute about their classification, and setting out, exactly what the relationship will look like ahead of time. That's not going to be the end all be all. We really need to make sure that the day to day relationship and the level of control and the ownership of tools and all those factors are indicative of this employee or this worker being a contractor. So not just it's not just important to have a contract in place, it's also important to look at sort of how much control are you putting onto this worker? Are you dictating their terms of employment? Are you dictating, when they start work, how they work, et cetera? And sometimes it takes those implementing those changes in the day to day that could help protect the company and make sure that this relationship is as you contracted for. So, you know, we can go through some examples. There's a decision there, Baker versus Fusion Nutrition Incorporated. I can fly through it very quickly, or we can go straight to Q&A. It's up to you, Michael, what you prefer. But
Yeah, fly through it. We still got a
great.
couple minutes to use that example. Then we'll go right to Q&A. Good question.
So very, very quickly, this is just one example of many cases, but there's a plaintiff in this case where they began working for a company for a few months. A few months in, they were provided with this independent contractor agreement, said, here, sign, you're an independent contractor. And it was for a fixed year, 1 year term. And this individual worked under this contractor agreement for a few months, and then they were locked out of the workplace, and they commenced a claim against the company claiming to be an employee. And so they wanted the remainder of the fixed term as damages for not being provided notice of termination. And they also wanted things like vacation pay and statutory holiday pay as well. And this individual, he was working, he was paid a monthly amount to generate sales revenue. And the court, he ended up proceeding, the company didn't defend, he ended up proceeding to default judgment, and the court agreed with him that he was actually an employee this whole time. And the reason for that was because his work was dictated by the company. He was working from their office. He was working full time exclusively for this company, and he had no opportunity for profit. He was just there very much going into work, getting his annual or his monthly paycheck essentially. And really, they found that this relationship, because of the level of control over him, he was an employee, he was awarded the remainder of the fixed term, he was awarded vacation pay, and also the holiday pay that I was seeking. So potentially it can be very expensive at the end if you have contractors who are actually employees. To end up that relationship, it's not sufficient just to rely on the terms of the contract. The court might disagree with the classification.
For sure. And that's a great example. When I think of topic number three, and the discussions I've had over the years with other entrepreneurs and business owners, they've often focused on the CRA risk and say, what if you needed to pay premiums, dating back a year, 2, 3 years? But really what you're driving home here for me, and it's not to diminish the risk around paying premiums because of some CRA ruling, but those premiums could be I mean, the more significant financial risk could be paying out like a severance or a notice period or vacation pay. I mean, this could quickly get into the tens of thousands or hundreds of thousands of
Exactly.
dollars. And one of the recurring themes of these live broadcasts, Zoriana, of course, is a little bit of due diligence before you enter these arrangements might save you tens or hundreds of thousands of dollars. So yeah, it really does kind of underline when I think of this issue, Zoriana, about
Mhm.
you better talk to a specialist in this. So let's go to the questions. Reminder, whether you're on YouTube or LinkedIn, you can ask a question. It's not too late. We already have some questions in the queue. I will remind the audience that we are about to put, as I say, Zoriana on the hot seat. And as she said at the beginning, there are a number of factors that determine these questions. So I think when I ask some of these questions, Zoriana, you're going to say, well, it depends. And you're not doing that to be obtuse about things. You're doing that because it actually depends. So
That's every lawyer's
anyway,
favorite answer. It depends.
yeah.
But
Yeah. We'll start off with a very specific question. And I don't know if you can handle or not handle this one, but I have a great response. I know it'll be a
mm,
educated one. Nick Christou, that's one I would have never considered. Can you
yeah,
ask a contractor to wear your company logo?
that's a great question. And I hate to say it, but it depends, right? Because
Yeah.
it's not one individual thing. Like if all
Yes.
the other factors show that he's a contractor, but he's showing up to an event or something and promoting your company, right? Like how will the courts look at that? How will a decision maker, the ministry, investigator, how will they look at that?
Yeah.
I would say, you know, at best, can you have them provide their own logo as well? Like
Oh
maybe
yeah.
they can have
Good.
your company shirt, but then have like a name tag with their own
Good
logo
point.
or something just to show like I appreciate you want them to promote your company and be part of the team, but you're getting into that kind of gray area of the optics,
Yeah.
and I know there's a case law about email signatures or having a business card. So if you're
Okay.
going to go that route, have a dual logo, have something to show that, this isn't somebody who's representing to be an agent of your
Yeah.
company as an employee. You want to
Yeah.
be careful with those things. Could you get away with it? It's a holistic overview. So if every other factor shows that they're a contractor, maybe. But it
Yeah.
is risky. It's risky to get to that stage. I think it's best if you are very clear. This is an arm's length commercial relationship. You are a company. They are a company that you're contracting with them for certain services. So I hesitate to see a situation in which you would want them to wear your company logo.
Yeah. Yeah, I like your suggestion, by the way. So, here's the scenario, right? That marketing company working for Ottawa Business Journal is called Acme. And, in their email signature on their shirt, potentially it says Acme representing Ottawa
Mhm.
Business Journal or acting on behalf of,
Yep, perfect.
and I'm probably going to get the language wrong, independent agent of Ottawa
Or
Business Journal.
affiliated with or something.
Affiliate,
Yeah,
yeah, yeah.
great,
So, I
great.
think, listen, I think what you just said there is going to be a recurring theme.
Mhm.
And talking about recurring themes, we have something's got to be going on in the dental industry because we have two questions from dental hygienists. And here's the first one. Thank you, Kelly Turner, for asking. So I'll read it out loud just so you can process it a little bit. Would dental offices using dental hygiene temps for a day or two be an employee if they used all of the equipment, processes, followed the office schedule, a temporary nature? I'm thinking of your comment about the ducks.
Yeah.
That's what
Um,
this reminds me of.
if that's one takeaway from today, yeah.
Yeah,
That I'm sorry, but my gut reaction is saying that sounds like a casual employee.
yeah.
It depends on, are they incorporated? Are they providing services? Generally speaking, I assume they're not. I assume that they're maybe they are incorporated, maybe they're not, but we're looking at all of the rest of the factors as well, right? So if they're simply there, is it through sorry, back to the question, was it through a temporary agency or was it just
No, it
a
doesn't.
pure
It doesn't
relationship?
say that.
Okay,
It
so
appears to be a direct relationship, but it's a temporary nature.
yeah, I mean, look, you're giving the ownership of tools, you're giving them the equipment, you're telling them come into this on at this hour to this hour. You're dictating how they do their work and when they
Procedures.
do their work.
You
Yeah,
said
it's.
procedures.
I'm looking at this being an employee. It's probably a
Yeah,
casual employee,
yeah.
but still very much an employee.
Walks like a duck, quacks like a duck.
Probably a
Uh,
duck.
yeah.
Yep.
Uh, by the way, I should say we're going to provide your contact information here, so we're being a little flippant. You should get independent legal advice on this. This is kind of the same. I just want to give out a shout out to the people asking questions. Selvia, and it's interesting, like what's going on in the dental industry here. And I do know there is a crunch for dental hygienists. Like they're
Mhm.
desperate to find these people. Are dental hygienists eligible to be independent contractors if they are part
Mhm.
time, taking no benefit from the office, using office equipment? Is kind of the same thing, but paying CPP taxes and everything for themselves. Oh, wow, that's even more
Mhm.
complicated. I
Well,
don't
it
know
sounds
what.
like in that case, yes, so they're responsible for their own taxes. They're responsible for they're not getting benefits through the workplace. They're getting paid as a contractor would. I would want to look at, are they signing an independent contractor agreement? Are they able to work for other dental offices? Are they able to, do they have to perform the work themselves? Are they able to delegate the work? Are they able to refuse work or, um, you know, negotiate, I guess, the terms of employment in the sense of the terms of work that they're being provided, when they can come in, et cetera, when they can end, what kind of work they're doing. It seems like a very sticky situation. Even if they are responsible for their own taxes, that alone may not be enough to say that they're a true contractor.
Yeah,
So the risk there is, the relationship may be fine until either the CRA audits or you get some sort of demand letter where they're asking for a severance package or they're asking the Ministry of Labor to investigate to see if they're entitled to certain things like minimum wage or overtime, et cetera.
yeah. I like the question you said there too. I'm picturing this as a bunch of check boxes, right? You're an
Hmm.
employee, you're a contractor. Are you working in both those questions? We won't get into it deeper, but are they working for other dentists or other
Hmm.
dental offices? Right, would be something we don't know when we're looking at both of those questions. We are running into overtime, but I want to bring up one other one here. A very technical kind of question. Thank you, Alan
Yeah.
Cram, for asking it. And the question is, can you comment about the importance of the T4, the T5018, that's beyond me, and contractors charging HST in their invoices? Thank you.
Yeah. So one of the pieces of advice I would normally give is, if you have a contractor, if you can, you should insist that they incorporate. It's another factor that they're going to look at when a decision maker is looking at the whole relationship. But it's much easier to kind of defend the relationship. You're saying, look, they're a contractor, they're paying for their own HST, they're dealing with their own taxes, we're not providing any sort of tax forms, they're on the hook for all that. And it would be ideal if you can point to a contract that says, we're in agreement on these terms. It's you know, it's only one factor again. So
Yeah.
if all of that were true, if this contractor is incorporated and is charging you HST for their services, but they are wearing the company shirt at the company barbecue and have the email signature,
Yeah.
and you dictate their day to day, and you tell them you're selling this product at this price, and you can't go outside of that. You can't hire your own employees. You can't XYZ. Then again, based on that, the courts are going to look at, where does the scale tip? It's
Hmm.
not just enough to say, well, they're incorporated, they charge me HST, we're done, we're fine, and that's the relationship that it is. It's not sufficient.
We will move to wrap up. Kelly Turner, who was our first, which was our first question, said she's not working for a temporary agency. So just quickly, I guess if you were working for a temp agency and they were placing you at multiple offices, that's probably pretty clearly a contractor, right?
Well, no, I would argue they're probably
Okay.
an employee if
Okay.
it's going through a
Oh,
temp
sorry, they're an
agency.
employee of the temporary staffing. They're
Yes,
not they're
yes,
not an employee of the dentist, a dental office.
exactly.
Yes. Yeah. Yeah, but that's a good distinction that you just made there.
Exactly.
Yeah. You're right. You're not an employee of the dentist, but you are an
Try to trick me
employee.
there, but I got it.
Yeah.
Yeah.
Yeah. Okay. Well, you passed the test. Okay. Listen, we're at did you do? Yeah, we're about 10 minutes over, but great question. Thank you for all of these questions. We will be providing Zoriana's contact information, but let's move to key takeaways and we'll bring up that slide for you, Zoriana.
Yeah, just a quick recap. So again, there's three types of worker relationships. We have the pure employees, the pure independent contractors, and that's sort of in between of a dependent contractor that is pretty reliant on the company for income. Then, we did talk about the factors that a court would look at, the test of is this worker in business for themselves, and the factors such as exclusivity. We're looking at integration to the workplace, ownership of tools, all those things, and we're looking at sort of a fact-driven, holistic overview of are they actually an employee or are they actually an independent contractor. And the reason it matters is because employees, they're granted a lot more protections under minimum standards legislation. They have entitlements to certain rights and certain types of pay, like common law reasonable notice, whereas contractors are not. And so the risk of misclassifying is that you would be subject potentially to an audit and have to pay taxes for withholdings not withheld, or you would be paying a termination package, certain back wages, vacation, etc. If you misclassify a worker as an independent contractor, but a decision maker finds that they're truly an employee subject to those protections. So in terms of reducing the risk, it would be great to assess the entire relationship. It is so fact specific. So looking at the day-to-day of the worker to really see, are they treated as an independent contractor? It's not enough just to have a contract in place that says one way or another. And looking at the language of that contract as well would be important, but more so the level of control over that worker in the workplace to see, are you classifying them correctly?
Excellent. Great job. We're going to bring up your contact slide as promised. So there is Zoriana's phone number and email. Also, again, I'll just reiterate that if you sign up in advance, if you register for these in advance, you get the slide deck and you get the replay link. So that's one of the big advantages to signing up in advance. Thank you, Zoriana, for spending all this time with us. I think, as we said, it's a really a fundamental issue that all employers need to be asking themselves, and it's a tricky one. But you provided us with a lot more information to assess whether these people are contractors or in fact Zorana. Thanks again for joining us. Really appreciate all your expertise and the work you put into this.
Thanks for having me.
Okay. All right. There's Zoriana Priadka from Eamon Harnden LLP. You can check them out. A reminder for all of you watching, you can visit obj.ca website every day for the latest in local business information. I highly recommend you subscribe to OBJ Today, which is our weekday email newsletter. It's kind of like the hot tips of everything going on in the local business scene. And that could be news, that could be upcoming events, it could be experts such as Zoriana providing that type of information. Please follow us on social media. OBJ's LinkedIn account has over 40,000 followers, I'm happy to say. And if you're watching right now on YouTube, do me a favor, click the red subscribe button and then the little bell icon. And if you do that, you'll get a notification on your phone or computer that we're live with these videos. Listen, I want to thank you for watching and or listening. I hope these broadcasts are making your business stronger and helping you make better business decisions. Hope to see you again real soon. Bye-bye, everyone. Cheers.